Hello, good day to you. Talkin really here, and today's story in The Independent is an 81-year-old lady has had phone calls pestering her from GPs to put DNR, do not resuscitate, onto her medical records. So, hello, and this story is quite shocking, but also this is the start of a legal action against Matt Handjob, after a phone call from a GP that she neither had dealt with before or had never seen even, requiring her to put DNR onto her medical records. And it was a 5-minute phone call. So now there is a legal battle that's been put forward. Kathleen Robertson, a former legal secretary, has now backed a bid for a judicial review against Health Secretary Matt Hancock over the government's refusal to set out clear national rules on do not resuscitate and end-of-life decisions, despite lawyers say examples of systematic violations of human rights across the country. And as you know, we have reported the DNR situation on this channel over the last few weeks, and they were told that they weren't allowed to do it. Miss Robertson, who lives independently in sheltered accommodation near Cambridge, contacted The Independent after reading about a bid for a judicial review against the Health Secretary by Kate Masters, whose mother, Janet Tracy, died at Annenbrooks Hospital in 2011 after a DNR order was made without her or her family's knowledge. Her family later won a landmark judgment at the Court of Appeal, which gave patients a new legal right to be consulted over DNR decisions. Miss Robertson said he was contacted out of the blue by a doctor at Lakeside Health Centre in St Neots at the start of April. She said, "I had a phone call from a doctor I didn't know and who I'd never seen and who only had my medical records to go on. He asked me about making a decision to put a DNR note on my records. It was completely out of the blue and I wasn't expecting it. There was no real explanation. It was a 5-minute conversation and there was nothing kindly about it. When I was approached to discuss this for my husband 10 years ago, it was very well done. This wasn't. It was a brutal conversation." After the call, she discussed the issue with her family and contacted the surgery to ask them to take the DNR off her records. The surgery said this could not be done, but has since added a new note to say that she should be resuscitated, but it has also added a treatment escalation plan for which Miss Robinson has had no explanation about what that means for her care. She added, "My concern is that elderly people are being asked to make such a decision without all the facts being given in a 5-minute telephone call. Some will be frightened and agree to it. Others will be muddled and agree. And some will have no idea what they're agreeing to, and I fully support Kate Masters' legal action against the government. Since the start of this whole pandemic, there's been concern about unlawful blanket DNR orders being put in place on care home residents and other vulnerable patients. Under the law, while a decision to resuscitate a patient is a medical one and not an issue for consent, doctors must consult the patient or their family and make a decision on the individual. The care regulator, the Care Quality Commission, and NHS England's chief nurse must have both issued warnings in recent months after reports of inappropriate DNR orders being made. Kate Masters told The Independent Miss Robinson's experience was exactly what I was worried about. She added, "The thing that concerns me is that this is the 3rd or 4th example I've seen of GPs calling people like this. I don't know where this has come from, but it's wrong, and I feel sorry for the people receiving these calls. I want to know what the criteria is. My fear it's based on age." She said a national policy and guidance from government would mean people like Miss Robinson would be aware of the issues and be able to access information and help. People faced with DNR conversations don't have access to the knowledge and have to turn to social media, journalists and lawyers, and this cannot be right. In her mother's case, the Court of Appeal judge warned that if there were systemic violations of patients' rights because of the policy had been delegated to local organisations, then the decision to delegate itself could be considered a breach of human rights. In a letter to the Health Secretary, Miss Masters' lawyers from Lee Day, we all know who they are, said, "We say that the extreme circumstance of the crisis has brought such a situation to hand. Our case is that the systematic violations set out in our evidence are a necessary consequence of a Secretary of State's continuing delegation of policy to a local level, and his failure to centralise, clarify and enforce the minimum standards of protection is through a direction with force of law is unlawful. With this power, the Secretary of State is able to prevent continuing breaches in a way that local healthcare bodies are no longer in a position to do." The DHS, Department of Health, said that it would not comment due to the ongoing legal progress. So, interesting developments on the subject of DNR. Keep watching, keep liking, keep sharing, and have a good day. Bye for now.